editor of Property Week. To be a fascinating discussion on how to reset the commercial landlord and tenant relationship. As we're all too painfully aware, that relationship has deteriorated sharply during the pandemic, with the level of litigation increasing both under the Landlord and Tenant Act 1954 and in response to landlords' claims for rent arrears. This month, the government published its new Code of Practice and Draft Commercial Rent Coronavirus Bill, which I think has just got through its second reading. And that's obviously with a review to repairing some of the damage that's been done. But is this all just a short-term response to exceptional circumstances? Will we go back to business as usual? Or has there been a real paradigm shift that will permanently reset the landlord and tenant relationship and lead to fundamental, long-lasting change? That's what we're here to discuss today. Thank you for joining us, whether online or here in the room. And thank you to Wilberforce Chambers for hosting this important debate. Before we get underway, we're keen for the discussion to be as interactive as possible, which is why we're asking you to put your questions to the panel via Slido. It's very straightforward to do, whether you're in the room or joining virtually. So feel free to ask questions anonymously if you wish to. All you have to do is go to slido.com on your device and enter WFPROP21. So that's WFPROP21 into the code box. It's not case sensitive. You can then type and submit your question. Okay, let's kick off the discussion. I'm delighted to be joined today by four panelists: Joanne Wicks QC from Wilberforce Chambers, David Cooper from David Cooper & Co, Tiffany Scott QC, also from Wilberforce Chambers, and Nick Wood from CMS. To set the scene, I'm going to ask a few questions to each of them individually, and I'm going to ask them really where they think things stand right now in relation to this landlord-tenant relationship. Now, David, as I said, the relationship between landlords and tenants has deteriorated sharply over the past couple of years. But for you, you see this as a long-standing problem, don't you?
Well, I do, and it may well be a long-standing London problem, but I've seen it get worse and worse well before COVID. The Landlord and Tenant Act itself is really heavily biased towards the landlord. I'm not here, by the way, to slam the landlords because, I do landlord work and I do tenant work as well. But the relationship now has deteriorated to such an extent that the cases that I get, both the landlord and the tenant, not acting reasonably. They've got financial problems, partly because of COVID, but also because of the banks. And I can't see there's any solution to this other than to rewrite the Landlord and Tenant Act 1954. That's what I've been proposing for years on end. It's got worse with COVID, but it was there before. And it's been really a sort of irrational approach, because if you take the West End in particular, and the posh West End at that, you end up with a situation where there's huge premiums in a good market passing on what's supposed to be fair rents, market rents on the rent review. So the rent reviews in central London do not reflect at all the value of those premises. And of course, this is making the whole system a fight, really, between a master and a servant at the end of the day. That's what it looks like to me.
What about mediation, though? Don't you think that could play a role?
Well, mediation is all very well, providing that it's on an equal basis. I can't see, having put it to my client tenants, they're not very interested in mediation. They think it's expensive and it's not binding, of course. This is the real problem, but it can go through the whole process and end up at the end of the day, preferably, with a lemon.
And do you think that tenants still think the dice loaded in favour of the landlords?
Well, indeed. And of course, the problem with the mediators are they are seen as being landlord related in one form or another. The barristers do it are seen to be landlord related. The surveyors who do it are seen to be, now that may be entirely wrong, but that's the perception that's being passed over to me. They're happier, frankly, going to court at the end of the day. And of course, the other problem is money, because the finances of the landlord and the finances of the tenant are not of equal value. This is the real problem in terms of going anywhere. And you've got the tenant, therefore, always feeling that he's on the back foot as soon as the argument comes about. And Joanne and I went to Francis and the Cavendish Hotel all the way up to the Supreme Court and then back again to the High Court as well. Yes, we had a wealthy client. Yes, we had an intelligent client. But more to that, we had a client who was going to put his time and effort into this as if it was his last-ditch effort. Now, you don't get tenants in that position able to do it. So I would like to see the Landlord and Tenant Act completely reformed. It won't happen, and I'll come back to that later, because I've sat on planning commissions and I've sat on taxation commissions, and they've all come up with wonderful reports and nothing happens.
Well, let's see if everybody else is quite so pessimistic. Nick, what's your views on the current state of play at the moment in terms of that relationship?
So thanks, Liz. So obviously the challenge today for us was the title of resetting the landlord and tenant relationship. And I think, as David has touched upon, we have seen a plethora of cases over the last 12 to 24 months through the pandemic, from pandemic clauses in lease renewals, and obviously, importantly, and no doubt we'll discuss this at some length, the COVID rent arrears cases, BNY, Mellon, obviously being one of those. And just standing back from those, one of the things that I found very interesting is this concept of the contractual allocation of risk. And I think if you look at a lot of the arguments in those COVID rent arrears cases, frustration, supervening illegality, failure of basis or failure of consideration, they are really driving at whether and to what extent we can interfere with the original contractual allocation of risk between the parties. And I think that's really, really interesting. And so in terms of us resetting this relationship, if indeed this is going to be reset, I wonder whether there are going to be changes. And for me, some of those may be the insurance regime that sits around leases, rent assessors, and obviously we've had the WH Smith's case on pandemic clauses in that regard, and then looking at some of the sectors, and this obviously doesn't apply across the board, but are changes developing, and perhaps this wasn't just pandemic driven, but the concept of property as a service, and looking at a totally different model where a landlord may say, well, okay, I'll take a higher constituent rent, but actually there's not going to be a service charge regime, there's not going to be any end of lease dilapidations liability. So again, in terms of resetting, are we talking about those sorts of concepts becoming more prevalent? And again, there've been turnover rent cases, and that's interesting for me, and no doubt something that we're going to come on to talk about is that juxtaposition of turnover rent and the 54 Act, and whether or not you can get a turnover rent through a 54 Act renewal. So I think that's what's really, really interesting for me, is if we're talking about resetting this relationship, that contractual allocation of risk, and is that going to shift, and is that going to change?
And what about the new arbitration scheme? What impact do you think that's going to have?
Where do we start on that? I think there'll be a lot to say about that, no doubt. And look, Joanne, I think, is going to perhaps give us some thoughts in a moment on how this is all going to work. So a few very quick points from me, and I know I need to keep my answers brief, but in no particular order, I mean, who is going to act as an arbitrator here? I think that's going to be very, very interesting. And multiple site issues. So if you've got an occupier with a number of leases that are all running into arbitration, and you're looking at trying to deal with viability and affordability, I think that can get quite vexed quite quickly. I'm not sure how we deal with that. And as a final point from me, Liz, on the arbitration scheme, and to throw out there, again, thinking about resetting this relationship, what about arbitration as a useful tool on a wider basis in the property sector? I really appreciate that's not new, and we're very familiar with arbitration in the context of rent reviews, but maybe a case can be put to using it as an effective, efficient, quick system of dispute resolution when those disputes arise, that could be of advantage to the property sector. So I think it's interesting, stepping out from this, that we're talking about arbitration in this sector, and I just wonder whether there's a case to be made for a wider use of arbitration.
I guess the issue there would be whether it's fairly, whether it is loaded in favour of one party over the other. I mean, what's your view, Joanne, on that? I mean, do you think it's going to be fair?
In relation to the proposed arbitration scheme. So obviously we're still in the early stages. It's draft legislation at the moment. There may be significant changes by the time we actually get an act. But I do think the question of fairness is really important, and it has a legal context as well, because obviously this is legislation which is going to interfere with landlords' vested contractual rights to their rent. It engages the Article 1 of the first protocol of the European Convention on Human Rights, and the government is going to have to demonstrate, if it's going to not face a challenge to the legislation and a declaration of incompatibility, it's going to have to show that it's fairly balanced, the public interest versus.
Do you think there would be a challenge then?
Well, I think anything's possible, isn't it? We'll wait and see. We'll take some views perhaps later on. But I think there are two aspects of fairness of the proposed regime. One is the question of, well, who's within it and who's without it? And then there's the other question, which is, if you're in the scheme, is it fair as between landlord and tenant? And I think in a way, the more challenging position for the scheme is the question of scope. I mean, if you're going to have a system which encourages or provides relief to commercial tenants, why not bring it in when you first close down those commercial tenants' businesses rather than waiting for 2 years? And then excluding from the scope of the scheme the tenants who have in fact already paid, who might rather regret that, or the tenants and landlords who have made an agreement and who might rather think that they would have done better by waiting for the arbitration scheme. It's ended up with landlords who have already bought claims being treated better potentially than those who've waited. So you have incentivized hostility, as it were, and you've rewarded aggression on the part of the landlords potentially. So landlords who already have judgments won't fall within the scheme. The tenants affected by those judgments won't have the ability to apply to arbitration, as I read the draft legislation.
So it will have the opposite impact to the intended then, if it's rewarding aggression and incentivizing hostility.
It's not an all-encompassing scheme. It doesn't bring into the scheme every tenant who's once had a rent debt arising out of a closure due to coronavirus. So it's patchily affecting different particular groups, and the group that it captures are those landlords and tenants who have not made an agreement or resolved their dispute nor taken proceedings until now. We know that there's about £7 billion worth of rent arrears captured by that. So it's obviously a large number of people with a large amount of money, but there are many people who don't fall within the scheme. And I think that's an interesting question. I think there are also questions about how the legislation will affect guarantors and tenants who have their rent liabilities guaranteed. It isn't at all clear to me that everything has been thought through. There are provisions in the bill which relate to guarantors, but guarantors can't apply for the arbitration scheme, for example, and there's no provision made, as far as I can see, at least so far, for the rights of guarantors to sue tenants if the guarantors have paid up, which creates a sort of three-way.
So it's not entirely clear how it's going to work in practice. Yeah.
I don't think it is. I think there are lots of interesting and difficult questions. It's been rather drafted on a sort of one-size-fits-all basis, and I think on the assumption that you're going to have a single landlord, a single tenant in relation to a single building, and it's all going to be rather straightforward. And as Nick says, I think where you've got tenants with multiple premises or group companies, I think there are a lot more complexities. I mean, what if you get a tenant, for example, who says, well, I could meet my rent obligations and be viable, but only if all my other landlords also take a haircut, as it were. How is the arbitrator going to deal with that?
And who's going to pay for the tenants as well?
Well, there are provisions in the Act, or the Draft Act, for some cost shifting in relation to the arbitrator's own fees. So the person starting arbitration will have to pay initially the arbitrator. When they make an award, then there's the potential for splitting those fees between the parties. But otherwise, everybody bears their own costs. And we can see the potential for the sort of uneven playing field that David's talked about coming in there, with tenants perhaps having an awful lot less firepower in terms of expert evidence, in terms of legal assistance, and going into bat against potentially some quite powerful landlords.
And Tiffany, are there any international examples we can look to that might sort of provide an exemplar, a blueprint of some sort?
Yeah, not exactly a blueprint, I wouldn't say. There are other schemes that have been implemented around the globe, and the government itself referred to the successful Australian approach when it first made its announcements in June 2021. There are more points of difference, if I can use that phrase, famously used in MasterChef, more points of difference than there are points of similarity, I think, with the Australian scheme. Just to say a little bit about the Australian scheme, the federal government brought in a mandatory code, and it was very early on in the pandemic, just to pick up on the point that Joanne was just making, back in April 2020. And it required landlords to offer their tenants proportionate reductions in rent in the form of waivers and deferrals, and that could be up to 100% of the rent on a case-by-case basis. And it's based on the reduction in the tenant's trade for the pandemic period and a subsequent period that's allocated for recovery. And the waiver constitutes no less than 50% of the total reduction in rent. So you've got to waive 50% of whatever the reduction is. And it could be more than that if it's necessary to allow the tenant to fulfill its ongoing obligations. But you also have to have regard, as in our scheme, to the landlord's financial ability to provide a waiver. So you're looking at both the landlords and the tenants' capabilities and financial position. And then the deferred rent has to be paid over the balance of the lease term. But if there's less than 24 months remaining, then you've got a further 24-month period, which is similar to what's been implemented in England. But where there is a difference is that if landlords and tenants can't reach agreement outside of a court process, then there can be a referral by either party to a lease dispute resolution process, and that's for binding mediation. So, and if you can't reach agreement at mediation, you then go on to the court process. So that's the first stream. Or alternatively to mediation, you can take the route of arbitration, where you have a binding arbitration, and that determines the outcome without further recourse to the courts. And landlords can't enforce any of the lease provisions or claim on any securities, just to pick up on the guarantor point, during this defined period, unless they can demonstrate that they have renegotiated and they're in the mediation process. Now, it's worth noting that that's at the federal level. You've got this mandatory code of conduct, and then each state or territory has implemented its own version of the code. So there's no consistency across those various territories. In fact, there's quite a degree of variation. So you have to look carefully at the particular provisions. And some of the methods of implementing the code are toothless, and so they don't give rise to any substantive relief. There's no actionable remedies that arise out of the process for the parties to deploy in enforcement. So the tribunal in Victoria, for example, can only determine that the landlord hasn't made a compliant offer, or that the parties haven't negotiated in good faith. And so you come out the other end with that determination, but there's no jurisdiction for the tribunal to order that the landlord needs to make a fresh offer or to substitute its own assessment. So, and why is this relevant? Because there are cases coming out of the courts and tribunals in Australia which apply their legislation, which it might be useful for us to study for our purposes, for our arbitration scheme, because they're being reported and they're substantive judgments on questions such as, how do you deal with, what's the level of detail that's required to establish, for example, whether a tenant's viable, it would be under our scheme. What's the level of detail you need for that? What evidence might be helpful to establish that there's a decline in turnover that's preferable to the pandemic, for example? if the tenant's post-lockdown turnover has been very healthy, how's that going to be taken into account? And generally, how is the arbitrator or the tribunal going to balance the parties' respective financial positions? So apart from that point of difference about arbitration and mediation, there's also in some of the legislation in Australia a provision that it only applies to companies of a particular size. So it's the smaller, in inverted commas, companies, so it's 50 million Australian dollars or less, whereas our scheme obviously is a one-size-fits-all scheme. There are also, I just want to mention
3 pages of notes here.
I know, but I just want to mention Spain, Germany, and Belgium. And thank you very much to Ashurst for a very useful article. Joe Perry from Ashurst has done an extremely helpful article on this that is published in the Estates Gazette. But in Spain, in Catalonia, the autonomous government of Catalonia has established an obligation for landlords to make a reasonable amendment. So tenants can require their landlords to make an amendment to the terms of their leases. And if there's no agreement within a month, then the landlord is automatically subject to a discount in rent. So count yourselves lucky, landlords in England, that you weren't subjected to that. And in Germany, there's more uncertainty, in fact, because there's an entitlement to approach the court if there's been a disruption to your contract, and it's now enshrined in law that because of COVID, there's been a disruption in the contract. It then goes off to court, but they have to consider all the circumstances to determine what the outcome is going to be. And in Belgium, they give tax reductions to their landlords if they consensually negotiated a waiver of part of the arrears. And so, and that, I don't know whether that was something that was considered by the UK government. I haven't seen it mentioned.
So we need to keep a really close eye on what's going on in multiple jurisdictions to take the best of what they're doing and try and avoid some of these sort of more toothless aspects that they're implementing. Yeah. Okay, we're about to go on to the sort of debate proper, but before that, I want to ask a Slido question to the audience, so the audience here and also the audience virtually. Reminder, the code is WFPROP21, and the first question I'm going to ask is, do we need fundamental reform of the 1954 Act? And the options are yes, no, or maybe. So let's see where we go. How long do we think this is going to take to get the response?
Pretty quick.
That is a little bit unexpected at the moment.
Well, there you go.
Only 6 or 7 people have answered. I think that's here we go. Okay, it's moving around quite interestingly here, but we've got 2/3 saying no, which no is now just over half. I wonder whether this is reflecting the bias in the room here slightly. I'm surprised a little bit by that. So it's 56% say no. How many responses have we had? Just 9.
Oh, it's good. It's
going up to whoa.
Every time he smiles.
Here we go. Now it's
how many times has David voted?
Yeah, David, you're
I'm
only
sorry
allowed
to say,
vote.
I think this reflects the fees that are payable to the professional, because most professionals, right, in my experience, are acting for the landlord. And the result of all that is, of course, they don't want it altered because it's a landlord act.
That's how you make your money, isn't it? Okay, all right. So 50% have said no, which was not what I expected. Now,
no, that's not what I expected.
Another quick question. Do you think the government is going about things in the right way with the arbitration scheme? And the answers again are yes, no, or maybe. I think some people are quite quick off the mark.
Quick on the fingers on the buttons, as it were.
The stronger. Okay, we're up to 85% saying no. Yeah, I can see how many people there now. Sorry, my eyesight isn't great, but I can just about see that one. Well, okay, 85% say no on that one. We'll see if a few more answer later on. Right. Thank you very much for those sort of introductory remarks. Now it's time to get the debate proper underway. Trying to cover a lot of ground, so if you can keep your responses quite succinct, that would be fantastic. So I'm going to ask this question to everybody. What impact does everyone think that the updated code of practice for COVID-related rental arrears will have? I'll get to you, Nick, first.
So keeping my answer as concise as I can. There are two iterations, obviously, of the code. The first one that came out a little bit earlier in time, and then the second one, obviously, published, I think, on the earlier in November. So for me, the first iteration of the code, perhaps being a little cynical, may have been seen a little bit like a direction to play nicely in the sandpit. And I'm not sure quite how much adherence there was to that code and how much bite there was to it. Second iteration of the code, I think, is more interesting. And it obviously comes simultaneously to publication of the draft bill. So admitting this bill may change and the scheme may change, I think there is going to be a lot of work done now on adherence to that code. And I think it's much clearer now as to what the gateways and framework of the arbitration scheme are, and what information you may be required to put into the arbitration, some of which may not be kept confidential if there's an open hearing. And I think that is going to bring into sharp focus whether on the landlord or the tenant side, what is the likely output or outcome if this goes into the scheme, these protected rents go into the scheme or not. And so I think, and indeed the government has said they expect a lot of this rent debt to be settled before we get into arbitration proper. And I think that may well happen.
Good. So you're quite upbeat about
I feel upbeat.
Yes, well, I'm extremely down. I have to tell you.
Tell me why.
First of all, both iterations of the code, as far as my clients are concerned, have not worked at all. I mean, they've just ignored it because there was no sanction behind it. And there was no reason really to go along with it. They could do what they wanted. And every landlord that I dealt with blamed the banks at the end of the day. It wasn't them, it was somebody else that was pulling the strings and they had to get the rent in. So I've got very little faith in the codes. As far as the arbitration system is concerned, will it sort it out? I doubt it. It may well make it better, but this government ought to be concentrating on what is the long-term problem of the relationship between landlord and tenant, because, you know, COVID one of these days will go away in terms of the rent, and this will just be a very interim matter. Yes, it needs to be dealt with, but it doesn't need the attention, the little attention that this government seems to give to anything, to be perfectly honest. Having voted for them, I can say this, not again. It's, you know, the problem with the whole system, of course, is that by electing a government for a 5-year period and trying to deal with a landlord and tenant situation, which is really going to be for the next 50 years, you don't get any motivation at all, because in order to reform it, you have to abandon it. You have to start again. There are so many lacunas in that act. I mean, I don't want to spend all my time telling you, but there are 4 things I would like to see. Number 1, rent reviews upward only should be abolished. Number 2, hypotheses about the length of lease that you take into account on the rent review should be abolished. Thirdly, there should be no assumptions in terms of the planning use other than the real planning use. I mean, to have some artificial planning use there, which is going to increase the rent, is also not acceptable. And those, just take those 3, they're fundamentally unfair to the tenant. And of course, the 4th one is that the tenant is left in a situation of take it or leave it. And there is no ability to actually move any further in central London than the limited amount of prime places that are on the market. And that just leaves the word manipulation in favor of the landlord. So I've got, you know, I'm very pessimistic really about this.
Well, you really want to see the 1954 Act overhauled, but you heard what people in the room said, and people watching. There was only 50% of them that thought that was going to be on the cards or a good idea. So just going back to the code again, Tiffany, what's your view on the likely impact of that?
Well, I tend to think that it's not really had much impact because it's consensual, and nobody's being forced to do anything. But that said, 80% of cases, we're told, have actually settled. But
does it need to be mandatory to really work?
In order to persuade people to enter into it? No, I think people will do whatever they want for their own commercial purposes, won't they? So it's only if it actually suits them to settle. That's probably why we've ended up with 80% of cases that have settled before arbitration. But there are various reasons why parties may or may not want to go into the arbitration process as well, that we'd probably come on to discuss. For example, tenants might want to avoid, might want to go into the arbitration process in order to avoid insolvency, whereas landlords, conversely, might also want to ensure that tenants don't enter into CVAs. And therefore go for the arbitration process. So whether it works or not and who's going to take it up are all commercial decisions, it seems to me, rather than everybody playing nicely in the sand, which is what the code is.
Joanne, is that all it is?
I mean, I suspect Tiffany and I see it from a similar perspective in that as litigators, we only see problematic cases. So I am rather cynical. I rather tend to think that people only comply with voluntary codes when it suits them, and it might suit them, taking up Nick's point, to demonstrate compliance with the code for the purpose of showing that to an arbitrator further down the line. But whether they would do it if there wasn't that arbitration backstop, I have a bit more doubt.
So are you a fan of the overhaul of the 1954 Landlord and Tenant Act as well?
I am. I don't think I'd not quite in David's place. What I feel is that the Act has been really undermined by the ease with which it can be contracted out of. I think that's probably a bit of a controversial view, but that is my view. In that it's that the tenants who need the most protection, the small businesses who don't have much negotiating power, who get presented with contracted out leases, which they then sign up to. And it's actually the more powerful chains.
So what would remedy that then? What needs to be overhauled exactly?
I would have, I would make it, perhaps abolish the ability to contract out altogether, or have it much more circumscribed. When it was originally brought in, the Law Commission in 1969 said, we think there should be an ability to contract out because people might want to grant a very short lease. But in fact, we've ended up with provisions which enable you to contract out any length of lease.
Okay, so that's the one big change you'd like to. We've heard about your 4 big changes.
That's my 4th change.
Oh, is it?
My
Okay.
5th change, because
There's a 5th one.
you know, when I look at what's happened in the last 2 years, I think virtually every lease that I've seen in the prime West End, the landlord have insisted that it's outside the Act and there's no security of tenure. Which, if you're putting in very expensive materials, or like we had in Francis, that we've got the goodwill of those particular premises, it's vital to stay inside the Act.
Okay.
Can I mention one other point, which is that the timescales in the Act are of the 1950s.
Yeah.
So that has problems both for landlords and tenants. But for example, if a landlord's got a large legitimate development project, it can be really difficult to put all that together and still prove that you're going to do it under ground F at the termination of the current tenancy. So I think there's a need for an overhaul to look at the practical realities on the ground of how things work in the 2020s that don't reflect the position in the 1950s.
Which would be, I mean, not easy to do, but you know, that's a good sort of starting point. Just update some of the elements. And Tiffany, your thoughts on overhauling
the 54 Act. Well, I tend to, there were 50% of people who thought that it shouldn't be overhauled, and I agree with those people. I don't think it needs a fundamental root and branch overhaul. There are tweaks, obviously, that can be made here and there, but from the perspective of a litigator, rather than someone at the coalface dealing with the clients or indeed drafting the leases, it's the gift that keeps on giving. The 54 Act is something that just when you thought you were comfortable with it and you knew what it was all about, then a new issue is thrown up that doesn't appear to have been considered before, or else you come up against conflicting judgments from county court judges that are not binding precedents, and so you can have cases where you've got 3 judges going one way and 3 going the other. And that does make it rather difficult to advise your clients then as to what the likely outcome is going to be. And I would like people to think about the possibility of there being a mechanism for these difficult issues of construction or points of principle to come before the higher courts without there having to be an appeal for determination. And that could either be enshrined in the 54 Act or it could be a matter of civil procedure.
That's really interesting. So let's see if the panel then reflects the audience. Nick, which way are you going? Overhaul or no overhaul?
Some overhaul.
Oh, good. So that's perfectly reflecting the results then.
Yeah.
It's a maybe. Go on, why is that?
So I think for me, and it touches on a point that Joanne has made, I think there are probably 3 areas where I would quite like to see some updating and review. The first of those is the framework in which renewal terms are determined. I think that could do with looking at and possibly updating. The second is rent determinations and interim rent determinations. I think section 34, without being too technical about it, I think that could do with some updating and review. Turnover rents being one issue that I think needs to be dealt with. And then thirdly, again, touching on what Joanne said, I have done historically quite a lot of sort of complex site assembly type work for redevelopments. And I think an overhaul of the grounds of opposition, the way in which those are assessed and determined, I think that is the sort of third area that I think could warrant a fresh look.
That sounds, so we've got half complete overhaul, one a bit of an overhaul, and one no overhaul. Okay.
Can I just mention that this act is fundamentally 67 years old. Now, most acts have been looked at in detail over 67 years. Why hasn't a landlord and tenant act been looked at?
I think we had, did we not have that sort of answer earlier that there's too much in it? And what did you call it? The gift that keeps giving. So I think it'd be useful actually to look at a couple of live cases and find out how they illustrate really what's required now. Let's start with this ongoing case about the cinemas at the Trocadero Centre.
Yeah.
Tiffany, can you talk us through that?
Yes, so people probably know quite a lot about this, so I'll just give the background. It's a claim in relation to the cinemas at the Trocadero Centre at Piccadilly Circus. The landlord brought a claim against the tenant and the guarantor for payment of arrears of rent and service charges of about 2.9 million. The tenant had covenanted under the lease not to use the premises otherwise than as a cinema, but there was no warranty given by the landlord that the premises could lawfully be used for that purpose. And so during the lockdown, premises either couldn't be used as a cinema or opening them up as a cinema was deemed to be uneconomic. And the landlord sued for the arrears of rent and was granted summary judgment. Now, the tenants argued that terms should be implied into the lease to the effect that the payment of rent was suspended during any period when use as a cinema was illegal. Now, the judge found that it wasn't obvious that such a term should be included. It didn't go without saying, and it also wasn't necessary to give the lease's business efficacy. And it comes back to this question of risk that I think Nick was touching on in his opening. Without any implied term, the risk was shouldered by the tenant, but there was no commercial reason why the landlord should necessarily bear that loss. And there'd been a negotiated lease between the parties, and they had determined that the risk should lie with the tenant, and that was a matter of negotiation between them. They'd also negotiated a rent suspension clause in the event of damage to the premises. So they'd thought about it in that scenario, and it wasn't obvious that a term needed to be implied, providing for a suspension in any other circumstances.
That's pretty complicated.
So there was a second argument that was run by the tenant, and that was that there'd been a partial failure of basis for the leases. The payments weren't due for the periods when the premises couldn't be used as a cinema. So they argued that you could split your lease up into time periods, so that there has to be a total failure of basis for this argument to work. So if you split your lease into time periods, you can have a total failure in relation to one particular period. And the judge liked that argument, but said, well, the tenant doesn't get that far because use as a cinema wasn't fundamental to the basis on which the parties entered into their lease. So tenant has applied for and obtained permission to appeal. Now, I don't know what's going on with that, but I think they were hoping for it to come on before March 2022, which is when the arbitration scheme is going to be implemented. And I think they're hoping that it will come on with the Bank of New York Mellon case, which is the case about rent cessor and insurance, so that everything can be dealt with at once. So yes, just another point to note about that case is that the landlord very much took the view that the tenant and the guarantor were able to pay the rent, but they'd simply chosen not to do so in order to preserve liquidity. So
that's a real issue, isn't it? I mean, that's getting in the way in a big way, I think. What about the case that was a catalyst really for this debate involving the S. Francis lease at 80 Jermyn Street?
So
talk us through that one.
thanks, Liz. I'm sitting fairly close to two people I think are fairly fundamentally involved in that case. But just briefly to remind ourselves of the main facts of the case, hopefully for the purposes of some debate on whether it is the catalyst for change. Two rounds to this, really. We remind ourselves that I think 2016, 2017, there was an opposed renewal. So the landlord was seeking to oppose any renewal by the tenant on ground F. And we remind ourselves that that ultimately went to the Supreme Court. And the main issue at that stage was, what intention did the landlord have to have in order to prove ground F and to prove that it was going to carry out the work. And of course, what the Supreme Court said is that that intention at its core has to be unconditional. So if the tenant was going to leave, the landlord would do the work in any event. So, you know, that's gone to the Supreme Court, no doubt at considerable expense. And interesting, I suppose, just to pause there, to think that some 70 odd years, I think, since the Act was brought into force, we're still perhaps needing to go to the Supreme Court to understand what intention a landlord has to have. So that's quite interesting if you just step back from it at that stage. And more recently, and again, just sharing with you the headlines rather than needing to go into lots of detail, but it then went back with the landlord having failed for an unopposed renewal. And this time what was at stake was a rent determination, an interim rent determination, and I think there were some other clauses in the lease that needed to be determined. I think the rent review hypothesis needed to be determined as well. And again, just, you know, some headlines that I think the evidence on both sides that was submitted to the court, I think was attacked, and I think it was felt that the landlord's expert was found in places to be quite partial. Might be understating that, I don't know. I'm interested to hear on some others on the panel. And you know, there was a lack of comparable evidence as well for the court. So particularly looking at things like interim rents and the framework for determining interim rent, the court had some difficulty in doing that. So again, just stepping out for today's purposes, we've had 4 or 5 years of litigation, opposed then unopposed, and I suppose it begs the question, you know, is the 1954 Act still providing us with the right framework to deal with both unopposed or opposed renewals? So I mean, that's just a quick run through, and perhaps others on the panel may want to comment, but hopefully that just, again, sets the scene for us on that case.
They're two really interesting examples, but do we think they are just to be judged on their own merits, or are they actually precedent setting?
Well, certainly the Trocadero case and the Bank of New York Mellon case are interesting examples of crisis producing new legal arguments and you know, encouraging a development of the law. I don't think it's any surprise that we have some quite interesting cases that come out of wartime scenarios, and COVID has obviously had such a big effect that it is producing interesting law. And just to sort of link back to the arbitration scheme, one of the things that I think is interesting, we've got this appeal in the Bank of New York Mellon case coming, I believe, in February, possibly with the Trocadero appeal at the same sort of time. If the tenants in those cases are successful and they demonstrate that they have a good defence to the claim for rent arrears, how is that going to play through the arbitration process? Because the arbitrator will have jurisdiction to decide not only if there should be a reduction in the rent, but whether or not there is rent due at all. And we could have quite an interesting and difficult set of circumstances where we've got quite interesting new law being made by non-lawyer arbitrators with the potential for appeals. But to go back to the Francis case, that's obviously very different. It's very, very heavily dependent on its own evidence, particular experts who gave evidence, the particular view of the judge, its own lease. It's interesting because we're kind of bereft of any COVID, relatively bereft of COVID-related cases about rent under the 54 Act, but it probably won't be of lasting importance.
But much reported.
Well,
I mean, what do you think, David? I think David might disagree.
I disagree. I think it will be of lasting importance because I think everyone should just recognise that the 2011 rent that was set for S. Francis was £220,000 per annum. And the rent now set for the next 15 years, subject to the rent review, is £102,000. So that is a massive, massive reduction. Now, yes, it is being followed out there because the tenants are seeing this, helpfully by me, by feeding it all around St. James's that this is the scenario. So the tenants are not offering anything like what the landlords are expecting for the rent. And hopefully the landlords will start seeing a little bit more sense. I mean, I do a lot of work in St. James's, and most of my work is not litigious. It's actually just the opposite. It's trying to negotiate sensible leases over a reasonable period of time. And, I genuinely believe that this case is going to have a major impact for at least a 3 or 4 year period before we get some form of recovery in the West End post-COVID. And as far as the Supreme Court is concerned, you've got to ask yourself if this act is working properly, why it is that the whole lot of the Supreme Court, turn the law or turn the interpretation of the act on its head, basically, after 60 odd years.
I wasn't saying that the Supreme Court decision wasn't precedent setting. That clearly is. I meant
I'll forgive you, but I think these things are important because they spread the word around, and you're dealing with sophisticated tenants actually in St. James's, and they're not going to sit back and watch a rent reduction of that nature over that period of time and not try and implement it. And that's going to lead to further aggravation. I mean, this is the whole problem with the system, that what's good for the tenant is bad for the landlord, and what's bad for the landlord is good for the tenant, and it doesn't really work. You've got to have a better system. Can I just say one last thing on this? Believe it or not, one of the companies I act for is taking a warehouse lease in Holland. Now, I know nothing about Dutch law, but I can read the lease, which has been translated into English. And my God, it's a much more even-based lease. It's based on the retail price index. Everything in there looks more balanced than it is over here. That's the only one I've ever seen, Tiffany, which is outside the UK. And it came as a shock to me that, how balanced it was.
I wonder whether, though, the whole COVID crisis might prompt a reassessment of it, if it even not a total overhaul of the 1954 Act, and that we might see some common sense prevail, I suppose. I'm going to combine the two questions I'd set for the final question, because we're running a bit short of time, and I want to make sure that people in the audience have a chance to ask a couple of questions. What impact do people think the pandemic has had? And where do we think we're going to be in 2 or 3 years' time with regards to the relationship between the landlord and tenant and this new code and the arbitration process that's being proposed? I'm going to start with Nick.
So very briefly, I think the pandemic and the crisis has brought about some extreme litigation given the factual backdrop. I think things will get back to normal over the next 18 to 24 months. On 54 Act reform, I think we've been talking about this since I've certainly been in practice, and it hasn't happened yet. So let's wait and see. I'm not holding my breath.
Okay, Tiffany?
I like the idea of turnover rents being possibly run with for a little while, but I think everyone's going to get excited about that, and then it's all going to go away. And it's all very market dependent, and it's all very fact dependent on landlords and tenants and their own they're different shapes and sizes, aren't they? And institutional landlords will want one thing, and smaller landlords and investors will want something different.
Do you even think there'll be finite take up really of turnover rents then?
Yes, probably, but pandemic clauses are probably here to stay, as we know, but it's shutting the stable door. I think Joanne mentioned earlier, it's too little too late for pandemic clauses. But what's going to happen in the next year or two, I don't know, but I know that the PLA has surveyed its members not that long ago and got a result that was similar to what we got this afternoon, 50-50, do people say that it needs reform or not? And the PBA hasn't even asked its members whether they're interested, and there have been no submissions to the Law Commission by the PBA in relation to reform of the 54 Act. So there's no drive from the professions, but I think the government has mentioned that it's going to look into it. And I think Joanne,
can you sort of add to this? Yeah, what do you think is going to happen, and what's the impact of the pandemic been?
Yeah, so obviously there's a market impact, but we're also in legal context talking about legal impact. I don't know very much about the markets really. I'm not in the markets. I'm only dealing with people who are fighting about things. But it seems to me part of the issue is that whatever gains tenants can make now as a consequence of market changes are unlikely to be baked in for a very long period, because most of them don't take leases for a very long period of time. So once the market swings back, it's likely to, I would have thought, that landlords will, that there will come to be business as usual. In terms of the legal consequences, I do think that there are things that might change as a consequence of the litigation that's been going through. And I mean, Tiffany mentions pandemic clauses, but I thought probably people drafting leases are going to be drafting their rent cessor clauses quite carefully from now on in a way that they perhaps haven't thought about. Perhaps tenants are going to be thinking more about insurance and what the insured risks are in their leases and those sorts of things. So I can see that those legal consequences of the situation that tenants have found themselves in and landlords have found themselves in might well end up with long-lasting kind of contractual change.
And you would hope that would improve the relationship, wouldn't you?
You would hope it would, yeah.
Okay, David, but you're not convinced.
I agree with Nick. Nothing's going to happen with this government to change the Landlord and Tenant Act, I'm afraid. That's not because it shouldn't, because it should. It should be looked at properly. But as I say, everything that's been looked at in planning and taxation is looked at properly, and nobody's ever done anything about it. Because unfortunately, I don't think you can tinker with these things. I think you have to really start looking at them all again. I think the relationship between the landlord and tenant was bad on a negotiating basis pre-COVID and is now dramatically worse. Whether it will recover and to what extent it will recover, maybe it will just go back to where it was, which was pretty awful anyway, rather than this even more awful COVID scenario. I mean,
do you not see any appetite on the part of either side to sort of resolve this and have a better relationship?
Well, we try, but the landlords, to be fair to them, are tied down. They're tied down by their bankers. They're tied down by their shareholders. It's not a free market economy. I mean, you can go and say it is, but it isn't. So they don't have the option. And there are some pretty bad landlords out there, as we all know. And those landlords are going to take advantage. There's some terrible tenants as well who take advantage of every single scenario. Unfortunately, landlord and tenant situations are a bit like family law, isn't it? Husband and wife. I mean, if the thing goes bad, you fight over everything, and it's sad. And I'm not sure how you recover it. I think the only way of doing it is to prohibit things which make the situation worse, and that can only be done by legislation. And yes, Nick said it won't happen. I agree with that. It won't happen.
Bit of a bleak note, isn't it?
Well, I'm sorry.
I'll take a couple of questions from the audience. So I've got them up on Slido. If you want to ask a question, just a reminder that the code is WF Prop 21. It's not case sensitive. So if you want to ask a question, please do. We're not going to have time to do more than a couple of these, really. Let's have a look at these questions. Which one do we think is the most interesting here. Let's have a quick, can you all read it? You've got it in front of you.
Can't see.
We've
too
got,
small.
So we've got one which says the code is required, ought to be mandatory.
yes, I like that one.
And the arbitration process is flawed. What about all those sectors and tenants that were not mandated to close, but still had a significant drop in revenue during COVID? I mean, yes, that's one of the interesting questions about scope, isn't it? I mentioned people who were outside the scope of the arbitration scheme, but clearly office tenants being the obvious ones who have no relief through this proposed legislation.
Yes, well, there's definitely an imbalance there, isn't there? And it could have been widened significantly to include many others, but that's obviously a policy decision that was taken. But yeah.
Okay. Does anybody in the room want to ask a question out loud, or shall I stick with these ones? Oh no, you're all shy. Okay. Let's have a look at this one. We've got one here that's. Let's look at what's the next one that we think is.
About resetting the commercial.
Yeah. Does resetting the balance to bring about a fairer marketplace not begin with the reform of commercial leases heavily drafted in the landlord's favour? Nick?
Gosh, where to start with that? I mean, at core, I suppose that's a market forces question, isn't it? And you know, one sees, I think, through different sectors at different points in the economic cycle, but the landlord or the tenant has a stronger negotiating position that is driven by the market, and it seems to me quite difficult to regulate that.
Don't you think as well, though, Nick, that we all have solicitors all have precedent banks, don't they? And the leases all look quite the same, and we've all got used to what a lease looks like and what sort of provisions it contains, and it does have an awfully long list of things that the tenant's not to do normally, and quite a short list of the things that the landlord's not to do.
I can't argue with that.
Unexplained quiet enjoyment. That's it.
That was quite a broad brush question. There's another one here from Stephen Kingsley. If a tenant, it's disappeared. No, if a tenant receives a 15-month COVID rent holiday, but is only willing to pass on a 12-month rent holiday to his subtenant who occupies the entire premises, does the subtenant have a significant argument for a longer period in arbitration? Who wants to take that? Nobody.
I mean, it's obviously got to be a factor in the arbitration, as it were. It's part of the whole thing, because the tenant, for these purposes, the landlord of the subtenant, and its financial circumstances are relevant to the question of what the subtenant ought to get. But ultimately, the arbitration system is going to depend heavily on what offers are made, and crafting those offers is going to be absolutely key, it seems to me.
Got time for one more question before we go to the final poll. Okay, as a question from Simone Ritchie, and it's going to pop up to the top. Yeah, good. If debts don't fall within the ring fence debt, and the that's the landlord, pursues for the debt by issuing debt proceedings, what do you think the court will do? Stay the proceedings pending the arbitration scheme being implemented, or ignore the draft bill and proceed as business as normal?
Super interesting question, I have to say. Well done, Simone. I think that's the sort of $1 million question. Obviously, we saw when the insolvency legislation was in draft form, the courts being willing to sort of preempt its passage. And the question is whether the courts will do the same again. Obviously, it chimes with the court's encouragement of alternative dispute resolution mechanisms, that they might use their court case management powers to stay existing claims. But the counterpoint to that, and if I were acting for a landlord, I'd argue that the policy of the legislation, once it's enacted, will be that only claims which were made after the 10th of November are intended to be caught by the provisions. And therefore, if there are existing claims, presumably the government intends them to be treated differently.
Good answer. Well, thanks very much for the questions, and for those joining us online for your questions. I'm going to find out now whether the discussion that we've had has changed people's views on those 2 poll questions that we asked at the beginning. I'm going to re-ask them. So again, the code is WF Prop 21. Do we need fundamental reform of the 1954 Act? See what we get this time.
See if you persuaded anybody more.
I should have thought.
Oh, maybe. We've got a lot more on your side.
It's still sort of leaning in the same way. Oh, have we actually had the opposite impact we wanted? Because I thought this was going to be an overwhelming, yes, of course, but it's really not gone that way, has it, according to the poll? So we've got 57% have said no, which I'm very surprised by. Second question, I'm going to ask this one again. Do you think the government is going about things in the right way with the arbitration scheme? Yes, no, or maybe? Oh, yes. Well, I think that's pretty definitive, isn't it? I think. Well, I don't know. It's come down a little bit though. That's no, it hasn't really. It's pretty much where it was at the beginning. It was 85% the first time, and it has dropped a tad. So I don't know what that says about the persuasiveness of your arguments.
Probably says some
I
of the people
think
have left.
it persuades me that the vast majority of this audience are acting for landlords.
You're probably right. Well, thank you ever so much for joining us. Thank you so much for the panel for some really powerful arguments. I thought it was really fascinating. And thank you those who joined us virtually. We'd be really keen to get your feedback. So if you could tell us via Slido how you found that, please do. Now there's some drinks available, I believe, in reception for those obviously joining us in person. I'm sorry, those who are not. Thank you very much.